Puckett versus U.S. Fire Insurance Company. This is a good example of how insurance works or does not work, but might still work depending on the facts. The opinion in this case was issued by the Texas Supreme Court in 1984. I will post the opinion on Moodle in case you want to read it for yourself. In July 1981, a Cessna 337 crashed in Texas. The pilot was named M. Hunter Puckett, and he died in the crash along with 2 passengers. A 3rd passenger was seriously wounded. At the time of the crash, the Cessna was owned by Puckett and a man named Robert Holt. The plane was also insured by U.S. Fire Insurance Company. Because Puckett died, his estate stepped into Puckett's shoes, and Puckett's estate had the right to be defended and covered by the insurance policy. The insurance policy was liability insurance. Don't let the name of the insurance company trip you up. And the policy was to protect Holt and Puckett, the owners of the plane, from liability to people such as the passengers or anyone injured in connection with the plane. Accordingly, the policy would require U.S. Fire to defend Holt and Puckett's estate from claims by the people or their relatives in connection with that plane crash. Of course, the survivors and the families of the dead made claims against Puckett's estate. They probably made claims against Holt as well, but we cannot tell for sure from reading the opinion. Somehow, U.S. Fire Insurance learned that Holt and Puckett did not maintain the plane's airworthiness certificate, which Holt and Puckett were required to maintain according to the insurance contract with U.S. Fire. Based on the failure to maintain the airworthiness certificate, U.S. Fire basically claimed Holt and Puckett breached the insurance contract, and so U.S. Fire had no responsibility to defend Holt or Puckett or cover any claims against Holt or Puckett. In this situation, the insurance companies usually have 3 options. One option is to defend the insureds but reserve the right to not pay any money if the insureds are liable. In this option, the insurance company will send a letter called a reservation of rights letter to the insured explaining that the insurance company intends to keep its right to claim breach of contract and deny coverage, and they're going to keep that right even though they are defending the insureds. In that situation, the insurance company will still investigate the claims, hire a lawyer, and pay other defense costs to protect the insureds. But if a judge or jury ever finds the insureds liable, then the insurance company might finally stand its ground and refuse to pay any more. Whether and when an insurance company denies coverage is a complex business decision for the insurance company. The second option is to refuse to defend and refuse to pay completely and at once, immediately. And in this case, the insureds might sue the insurance company. 3. The third option, sue the insureds before the insureds can sue the insurance company. This is the option U.S. Fire Insurance chose. U.S. Fire Insurance sued Puckett's wife because she was the representative of Puckett's estate. U.S. Fire Insurance also sued Robert Holt. U.S. Fire filed the lawsuit in district court in Randall County, Texas, and asked for an order saying U.S. Fire had no duty to defend or cover Puckett or Holt. Holt and Puckett's estate responded to the lawsuit and freely admitted that the airworthiness certification had expired. Robert Holt explained that he and Puckett were thinking of selling the plane and were not sure if they needed the airworthiness certification to sell it. Holt and Puckett did not want to pay for the certification if they did not need it for the sale. Eventually, Holt and Puckett decided to go ahead and get the certification, but the crash happened before they could. Holt and Puckett also claimed that the airworthiness certification was irrelevant to the crash. I would summarize their argument this way. The expired certification had nothing to do with the crash and did not affect U.S. Fire in any way. So even if the expired certification was a breach of the insurance contract, it was not a material or relevant breach, so the insurance contract is still enforceable. The judges and justices called it a causation requirement. If the breach did not cause the insurance company any loss, then the breach was irrelevant. The justices of the Texas Supreme Court said, "The question presented is whether an insured's failure to have his plane inspected need be the cause of an accident in order for the insurance company to avoid liability." The district judge in Randall County disagreed with Holt and Puckett's estate. The district judge made his decision based on the plain language of the policy and let U.S. Fire off the hook. Holt and Puckett's estate appealed their loss, and they lost again. On appeal, the Seventh Circuit of Court of Appeals, which is located in Amarillo, agreed with U.S. Fire that there was no causation requirement. Holt and Puckett breached the plain language of the insurance contract, so U.S. Fire was not bound to defend or cover the insureds. Holt and Puckett appealed to the Texas Supreme Court, and this time they won. U.S. Fire admitted that the failure to have an airworthiness certification in no way caused the crash. So it was a simple question for the Supreme Court. The justices looked at the law in 16 other states and decided to require causation. They analyzed the case and stated in their opinion 3 rules that the justices believe were the law in Texas. 1. Insurance policies are strictly construed in favor of coverage. Specifically, when in doubt, the insurance company loses. 2. Courts are supposed to follow the plain meaning of a contract, and the U.S. Fire Insurance Company contract plainly does not require causation. It plainly requires an airworthiness certification. So number 2 is in favor of the insurance company. The third rule that the justices stated was this: it would be against public policy for an insurance company to avoid coverage on a technicality. In the end, the Texas Supreme Court said the technical violation of a policy does not allow the insurance company to walk away if there was no causation. But it was a split decision. 6 justices voted in favor of requiring causation, 2 voted against requiring causation, and 1 voted for something completely different. But that is the law today. Causation is required for a technical violation of an insurance contract before the insurance company can wiggle out of the contract.